Hope everybody's doing well. Welcome to eState Academy. Thanks everyone for joining us. And we're thrilled to revisit a topic, Ian, that I get questions. I can't say it's every day, but I think every 2 days from practitioners, from clients, and others about this seemingly simple solution to the issue of trying to control what happens when both spouses die. Any before we get to the agenda, any opening remarks?
Yeah, I do. This topic, I sort of had just 4 quick points. One is there is a public perception problem. Clients come in expecting, couples come in especially expecting that there is something more going on than is going on legally with regard to mutual wills / mirror wills, which we'll talk about. So that's always a red flag to me that I want to make sure that I've just, sort of directly dealt with that known public perception as to what they think a will is actually doing in this regard. If we get into a problem, it is a complex evidentiary quagmire, and we're going to see that when we talk about some of the recent cases on this. As you say, solutions exist though, and lawyers have, I think, a pretty clear obligation on how to march our clients through this, and that solves my first point, and that is the public perception. So I'm looking forward to trying to get through this. We have a lot to cover, so we may not get it all done in one, but look forward to trying.
Oh, we're going to do it. We're going to do it. Have faith. So we're going to talk about the difference between a mutual will and a mirror will, the requirements to prove a mutual wills agreement, who bears the burden. We're going to look at the Court of Appeal decision in Geffen. We're going to identify all the problems and issues, not all of them, but many of them with mutual wills. Look at other options, and then what's our responsibility as advisors and lawyers on this. So here we go, Ian.
All right, buckle up.
All right. So just the distinction here. Mutual wills are a very special type of arrangement. They actually don't describe the will so much as the agreement between the parties who made wills. Mirror wills, on the other hand, are just two wills that look the same. They're mirrors of one another, also called reciprocal wills. I think part of the problem with the distinction is they both start with M, mirror and mutual. If that didn't happen, we wouldn't have as much confusion. But mirror wills are just two wills that happen to look the same, but with no agreement otherwise. You just interpret them as they stand. Mutual wills, on the other hand, are not only wills that have a similar dispositive provision, there has to be an agreement between the two testators not to change their will. That's the key. It's not just that the wills are mutual or mirror, it's that there's an agreement not to change them. And that's
the central point, right? Like when we get into this, we've got it. We can go to the next slide for sure. This is all about agreement, and is there an agreement there? And that's where lawyers can help guide our clients through this to make sure that there is clearly one way or another. And as you've identified, there's an express agreement or there's an implied agreement. And of course, when we get into the implied agreement language and sphere, it's where we get into trouble and we get into our dark hole of evidentiary burdens.
Right. So, an easier case is as to whether there is a mutual wills agreement is whether there's an express statement to that effect, right? That's the easy one. The key here is the implied agreement, and that's where we're going to explore mostly from the litigator's point of view, like or just people who are interested in how we deal with this, like how do we find that there's a legal contract, a binding legal contract? And that's really the key here. It's not just a moral obligation or an understanding or, a wink, wink, nudge, nudge. There has to be the finding that there is a binding legal contract for there to be this mutual wills agreement that's going to stop this survivor from changing their will. That's what's key.
And you can see, as we talk about the requirements, when you as you just said, stop the change of a next will. Like that is a profound hard stop for judges to get their heads around. And of course, the requirements we'll talk about just in 2 seconds, it came right out of the Reed Gillespie decision, which was what a case of my dad did actually in the late 60s.
Right.
And he always tells the story that he thinks that it was going badly for him until after lunch, and he's quite convinced that one of the judges had more to drink at lunch than anyone else in the room, and we don't know which one. He never gave me the full story, but the point is. This requirement for mutual will agreement, it is a contract. It's an agreement. It's all the stuff we learned in first-year contracts, and it's without express language, it is very difficult to ever see the courts imposing it. And we see it. We're going to see it in the case law as we discuss in a minute. But the courts really struggle with this because they go back to first principles. You better have clearly identified that you want to restrict future testamentary moves.
Yep. And we'll see what the Supreme Court of Canada says about the burden on trying to do that. So you've got to, here are the requirements. Okay. It's got to be a binding contract. It must be proven by clear and satisfactory evidence. We'll talk about that in a second. And it must include this agreement not to revoke a will. That's really what the requirements are. And the goal, of course, is to prevent the survivor, who is typically the beneficiary of the first to die's estate, not to change their will and change the distribution of their estate. So, yeah. Ian, you've dealt with these cases and argued them, and what, absent a specific statement, an express agreement, here, maybe take us through some of the evidence.
Yeah, and this is really it. I mean, then you've identified the 3 cases that tease this out, but these are the sources. And the will is actually, in my experience, the main starting point for a bunch of reasons. But if you look at it, and we don't have the Hall estate here, but some of the other cases where mutual wills was dusted up in, the courts really do focus on the language of the will itself. And so, oh, look at you, you're way ahead of me, but I just didn't have it on that slide. See, why would I question you? And so we're looking at the will itself. And then, of course, the statements of intention. Again, that's just a whole rabbit hole of evidentiary burdens that you're going to create in a litigated environment. It's a he said, she said situation, who said what, and of course, can carry the day, as it does carry the day in the Geffen estate, which we're going to talk about. The reciprocal wills, of course, are something to consider. And that's what in the Hall estate, where they had mirror wills, and the court toyed with what that meant. Like, does a mirror will get you to the mutual will status? And that's really where I was talking about the public perception problem. People come in and say, I've done mirror wills with my husband and wife, and I trust that it's never going to be able to be changed. They have an expectation that somehow that estate plan is locked in as between the spouses. Then, of course, this is where it gets so good. Like, this is why we make our bread and butter as litigators. You get to talk to third parties. You get to talk about what are the family relations and any of the evidence of the lawyers and things like that. You get to poke away at the lawyer's notes. All of that. It's just great stuff that drags out discoveries for days on end and puts nothing but money in the pocket of litigators. But you can see, joking aside, this is how difficult the proof of these agreements get in all of these cases, even when you've got express, because even the express language can get picked apart.
And one thing I just want to point out, the evidence of the lawyer who took the instructions, especially if there's, again, the agreement doesn't have to be in the will. You can get it from the surrounding circumstances. The evidence of the lawyer is very important. And often you see criticism of the lawyer who drafted the will saying they didn't even inquire into this issue, and that would have solved a lot of the issues. So we're going to come back to that in a second.
And just the last point on it too is I've seen many times in the cases where the lawyer uses the term mutual within taking notes, where it's inadvertently creating a mutuality.
Right, and they meant mirror. They went.
That's mirror. Right. That's right.
So just quickly, there was some discussion. This ties in with the Geffen decision, because they looked at what the trial judge talked about, the heavy burden on those alleging a mutual wills agreement. The court was clear that there's only one standard of proof, which is a balance of probabilities. the burden is on the person alleging a mutual wills agreement. But they did go into talking about and cited the Fairmount Hotels case from the Supreme Court of Canada that talked about the quality of the evidence. Yes, there's no higher level of balance of probabilities, but the quality of the evidence must be sufficient to displace the fact that the agreement, the will on its own, doesn't say anything about mutuality or a mutual wills agreement. And so they talked about cogent and convincing evidence. And so if you're fighting one of these cases, Ian, I'm sure you've used this before, it's like, just don't allege that there's a mutual wills agreement. You need really good evidence about it. And so that's what we're
Yeah,
talking.
and there's a reason why there is really just a handful of decisions out there in this area where it's succeeded, and there's also a handful of decisions that it's actually been litigated, because that high bar of what is that expectation, because it just comes back to the right policy behind this, right? Nobody goes into a situation that limits their testamentary freedom going forward easily, and that's what a mutual will does. And so that burden is quite properly heavy.
And that's reinforced by Geffen. And that's what the Court of Appeal finds. But obviously in this Geffen case, I think I was reading the case and it said there were 60 fully argued motions before trial. And, I mean, it's a crazy case, but pretty classic, right? I mean, husband and wife, they prepare mirror wills. The lawyer's evidence that say, look, they never told me about some agreement, but interestingly, he didn't inquire about that. So this goes to trial, and then the decision, we'll see in a moment, gets affirmed by the Court of Appeal. But so they make these mirror wills, and then after the mirror wills, the husband writes this note, and he says, basically, we've agreed that no one's going to change, neither my wife or I will change our wills. That's our intention, that we're going to divide everything 3 ways. They had 3 kids. Now, the wife doesn't sign that document, might not even know about that document, but there is evidence that the wife said, yes, we have one will, me and my husband, me to my husband and my husband to me. So in other words, no trust imposition, but also that it was her intention that the residue be divided equally when they both died. So there was evidence of mutual, understanding, if nothing else. And Ian, you know this case pretty well. I mean, there's terrible discord among the family, and the husband considers changing his will, but then lets everyone know that he's relying on the concurrence of his spouse and the understanding that she won't change the will, and so he's not going to change his will. And so we have that, and then the husband dies. Things happen, and basically the court at trial, which is affirmed, says there is not clear and cogent evidence of an agreement. The admissions by the wife, or that she kind of was going to give everything to each other, was not enough. And there was evidence both ways. The wife didn't sign that note that the husband made, and as well, it looked like the husband was contemplating changing his own will, which would have negated this agreement that they neither could change their will. So the Court of Appeal, agreed with the trial judge that there was no mutual wills agreement in this case. This is what the court completed their decision with.
Yeah, and I've been quiet on the description of this case because I was a witness in this trial.
Oh, okay.
And I'm joking. I was a witness, but I'm not why I'm quiet. You're just doing such a good job. But I was actually my dad had the famous ability to argue one of the early mutual wills cases in the Court of Appeal, and I got the second chair by being a witness at this trial. So, but I say that actually quite happily because, again, it tied into the rabbit hole that the court and the parties went to grab at evidence of any sort where even the professionals were involved to sort of link in to create this agreement. And I was a fact witness to it because of the early stage I was involved in the matter. So it's just, again, the decision is pretty straightforward. It's sort of, it's just wasn't sufficient to create those hard parameters of an agreement and classic contract law that the courts are going to expect, and the high standard of the evidence that has to be led. So the court wasn't persuaded to go there with this one, but you can just see the mess that gets created by the nature of the evidence that can be led. And I was probably one of 30 witnesses.
Yeah, it was it was a huge case. And maybe because the case touched on so many other things like secret trusts and other things, maybe we could spend a whole day just on or a whole webinar on the that case and the number of different issues that are informative. And anytime you get a decision from the Court of Appeal on one of our case areas, you want to pay attention to it. So
yeah, and it was so well reasoned at the trial level. She had Justice Kimmel, and Justice Kimmel, I think, had been appointed about a month, got this trial, did such a great job because you're right. We have probably 5 sessions we could go through and these other issues that were considered. But again, it comes back to the same point. If you're going to go after a mutual wills agreement, you kind of throw a lot at the wall if you're trying to say there was one, because it's so hard to pick up the pieces.
Yeah, and obviously what's the effect of finding that there's a mutual wills agreement? This is the core, this is the nut, right? And the point is that we kind of say, oh, you can't change your will. Well, a will is always revocable. I mean, by law, it has to be revocable in a sense. So it doesn't actually say that will is not valid, but what it does do is it imposes, if there is a later will that changes it, there's a constructive trust that's imposed over the assets to ensure that the terms of the mutual will agreement are fulfilled. The big issue, of course, is when does the constructive trust cover those assets, and what assets does it cover, and what can the survivor do? And let's just turn now to those issues, and these are really the fundamental problems with a mutual wills agreement. If we just say, oh, we agree not to change our wills, well, okay, but we all know that you can do things while you're alive. You can keep your will the same, and it actually has no effect, because in essence, you give away all your assets, or you spend them, or you do something, you make them joint, or you do some inter vivos steps to defeat the effect of that will, even though you're not changing it. And so,
yeah, sorry, just on that point. And just on that point, and in Geffen, but in most of these cases, they talk about the surviving spouse. What are they to live on? Are they to go back to shopping at only at Walmart because that otherwise they're dissipating the assets in a way that wasn't anticipated? Are you not allowed to give a donation to sick kids? All of those issues were hashed out in Geffen because it undermined this whole idea that this couldn't possibly have been couldn't be in existence, that there was a mutual will agreement. The parties didn't anticipate that unless you contractually identify how it's going to be.
Right. And the problem with this solution, and which we'll see in a second, of a mutual wills agreement, is that it doesn't address all these important things. Are there limits on what they can do with the inherited assets? And are there limits on what they can do with their own assets? Because maybe the intention is that the collective group of both spouses' assets are to go in this way. That's in essence what they're trying to do. And then we have all these issues. So the terms of a mutual wills agreement, if you're going, and one thing is, so just Ian, you may agree with me or not, I would never personally draft a mutual wills agreement. We're going to talk about other alternatives, but what are the terms of a mutual wills agreement? You can't alter the will's dispositive provisions, but can the survivor spend any amount on themselves? Can they gift any amount? And if so, are there any limits? There's a case of Justice Patillo in the Nelson case dealt with exactly that. There was a gift of $200,000, and the question was it substantial, and those kinds of things. And so those limits on what a spouse can spend, and you identified that, Ian, as the big issue, right? There. And does it only govern those assets that you inherited from the spouse? That's what you have to give to the ultimate beneficiaries. Or does it also cover your own? And what happens if you acquire other assets? You win the lottery the next day and you want to give that to someone else. Does this mutual wills agreement cover that? And does it apply to other inter vivos planning? And so you can see the myriad of issues that come up here.
Yeah, and I think that it's interesting because remember in the 60s, of course, you'd see, and we still see them from time to time, mutual wills.
Joint,
Which,
one will. Yeah.
And sorry, joint wills. And so I actually go maybe one step further, in total agreement with you. I don't even think it's actually something I wouldn't do for sure, but I'm not sure it's something that can be done from a drafting standpoint. It's one of those endless drafts in many respects. You've just identified 6 of the points that you can grow this thing into one of these documents that it really is sort of a deep hole that you're never going to get out of. And the funny thing is we're just got to talk about is there are simple solutions. There are alternatives that we can put to our clients that directly address precisely what they want to do. And this is an important issue for second marriages or second relationships. So it's not like we don't have alternatives.
Yeah. And listen, a mutual will agreement is a possibility. It is an option, but simply a statement. I guess what I'm cautioning you or everyone about, and it's your decision, but a simple, clause in the will that says, we both agree that this is a mutual will and we're not going to revoke our wills. That to me is kind of the worst possible solution you can have. That only calls into, that's going to open up.
Well, that's the point. Like, I think you can draft anything, but I'm just saying, I'm not sure you can properly draft a mutual will agreement is what I'm getting at. I really don't, there's great drafters out there, but I think because of the pitfalls when you have these 2 alternatives, obviously a proper domestic contract, which is again something that is widely acceptable, and then spousal trusts, which gives you gives you parameters to address all of these issues that you just had in the previous slide. Who's going to be in charge? What are the levels of lifestyle spending? All of those sorts of things. Making sure that you're right, like after acquired properties is simply addressed. If you choose to use some of the money from the income that you're generating to buy a stock that goes through the roof, like why does that necessarily have to go as a consequence of some sort of agreement that you entered into? Well, if you have a spousal trust situation and you're enjoying the income and you go out and buy the right stock, that you should be able to do with that as you see fit. So I guess as we're going to turn to this question of the lawyer's responsibility in a minute, I guess I question, why do we talk about mutual wills agreements when there is alternatives that are much safer for the client and much safer for the lawyer?
Yeah, and I agree. Spousal trusts are the classic way of doing it. I sometimes see these mutual will agreements because they're like, we don't want to use a trust. We don't want to use a trust. We want to avoid probate tax or something tiny like that. Well, mutual will agreements to avoid probate tax, I don't think the cost benefit analysis is there. Spousal trusts do what you want. You get the money, but ultimately it has to go to these other people. But it doesn't restrict what the survivor can do with their own assets. And maybe that's a good thing, maybe it's a bad thing, but spousal trusts are really are the solution for many of these discussions. And the problem is we don't have a perfect solution because spousal trusts and trusts generally cause their own issues. Just somebody had a quick question, but the trust that's imposed on a mutual, where there's a finding of a mutual wills, is a constructive trust. It's not a bare trust. It's a constructive trust. So let's just talk about lawyers' responsibility here. So that these issues might not, so somebody after the fact doesn't come up and say, oh no, this was a mutual wills agreement, or it's not binding or whatever. So do you want to take
Well,
this?
yeah, and I mean, I think that your first point is vital, and that is just to your notes reflecting that the discussion has included the understanding as between an absolute gift and a trust, and that using your old analogy, that there are strings attached or there's no strings attached, and that the client understands that basic decision at that point in time is so important.
I mean, I say it about 5 times in my meetings. And if you are an eState user, in the reporting letter, if it sees that there is an absolute gift to a spouse, it recognizes that and it reports that out. And so, I think that's really crucial, for sure. But that doesn't mean that you shouldn't be discussing, and I think it's really important to discuss the use of a trust or other options so that even makes it clearer to them that they have an option, right? They're choosing an absolute gift with no strings. And they knew that there were other alternatives. There was a use of a trust, etc. And so I think that's part and parcel for that. And then you don't get the criticism that you see in Ramage and those other cases where the lawyer who took the instructions never even inquired about different options. Obviously, documenting the discussion and the instructions are crucial. And I mean, I put it as blunt as possible. You're giving it all to your spouse. They're going to remarry and give it all to their new spouse. Is that okay?
Yeah, that's right. And it's sort of like the same discussion I have with people at the same level when they do powers of attorney. It's like, this is a blank check, just so you know, and this is the consequences. And, if you set it to them straight, they're usually in a trusting relationship and they've got confidence. I mean, things can happen. They can give it all away after, but it's an easy discussion to have, I find, with your clients, because once they understand the quagmire that's created with the mutual will arrangement, they tend to run from it as fast as they can.
And if you're going to be involved in, a mutual wills agreement, it's got to be comprehensive in my view, and it's got to be with disclosure and independent legal advice. Arguably, a mutual wills agreement would fall under the definition of a domestic contract under the Family Law Act. Knowing what assets are being covered and what what your assets are and what your spouse's assets are. I mean, I think that's all part and parcel if you're going to go down that route. So that's something else to keep in mind. The last thing is when a client comes in and says, I'm widowed, and I inherited money, and now I'm going to make a new will, and it's different from the one they had with their spouse. Getting some kind of evidence that there wasn't some sort of mutual wills agreement, at least documenting that is I think also in a good idea. You'll see that in the Ramage case as well, where the lawyer doesn't necessarily ask about it, and so they do a brand new will that's different, that violated this mutual wills agreement and caused a bunch of trouble. So obviously, just to address one other question, we're going to and maybe I'll do this after. There's a few questions we'll do post this meeting, but or this webinar. I'll stay on for a few minutes after. I know, Ian, you've got to run. So the last thing I want to just address in our 30 seconds are the important cases that are on this topic. The good news, if you're new to eState Academy, we give you the slides. We send you the recording, we give you the slides, and we're hoping to help you and make it easier for you. We appreciate the great group here. We're here Thursdays. Next week, I want to announce this because it's a really great topic. Bare trust reporting. So Ali Spinner, an accountant and an old friend of mine, is coming to speak to eState Academy about what are our obligations for reporting, not only regular trusts, but our obligations to report bare trusts to the government, to CRA, with the new reporting requirements. So please don't miss that. That's a really important one. And thanks, everybody. Ian, thanks. Great to see you. We'll see you again soon. Thanks, everybody. If you'd like to post comments, feel free to post them in the chat. We appreciate it. If you have any feedback for us, we appreciate feedback and that kind of stuff. I'm just going to take us through a few questions here, and then everybody's obviously welcome to leave whenever. But so we've answered a bunch of these, and I just want to address the issue about joint property and using a spousal trust. Obviously, spousal trusts are not an option if everything's joint, and so query if everything's joint. That's going to be an issue if you're trying to impose a trust on the property. So that's when you need some sort of, if you're going to do it, if that's so important to them that they have joint assets, there, then you're into some other agreement, a mutual wills agreement, those kinds of things. Again, they're fraught with difficulty. They're expensive, but as well, in the sense that they should have, I think, independent counsel for both parties, and all those other things that we mentioned in our slides. So those are my comments on that. And let me just see if there's anything else that anybody had. No, that's great. Well, thanks, everybody. And we hope to see you again next Thursday. Next Tuesday, we have our eState eState Planner users webinar, where I'm going to host that on this coming Tuesday. We have some new features, and we'll tell you about that. And we'll also refresh your memory on customization of documents, so you're getting your precedents coming out the way you want them in eState. Thanks, everybody. Have a great rest of the week and a weekend.